In this presentation, we will be looking at the role and the function of the Court of Justice of the European Union, and we'll also be discussing the whole concept of European integration and examining whether this occurs by treaty or through judge-made law. This is a presentation by Mrs. C. Bradley of Europe Direct, Eastleigh. If you'd like further details on the Court of Justice of the EU, you can go to their web address, which is http://curia.europa.eu/jcms/JO1/6308. If you go to the Curia website, you can find full details of the institution itself, how it's composed, and also do a search on the case law of the European Court of Justice. In terms of lecture outline, as an introduction, we'll be looking at the basic principles and features of the European Court of Justice and examining how it has a low profile, but it's still been a major actor in European integration. We'll be looking at how the court is constituted and how it works, and the composition and procedure of the court. We will also be examining who can bring actions before the court and the impacts of judgment on European integration. We will also be doing a critique and a defence of the court. Does it apply the law or does it make the law? Is it a legal body or a political body? And finally, we will be concluding that European integration has occurred through law and also judicial activism by the ECJ. Now, the ECJ has a low profile, but it's a major actor in EU affairs. It's less known than the political institutions, and it's a self-assured body conscious of its authority and power. It's not to be confused with the International Court of Justice in The Hague, nor should it be confused with the European Court of Human Rights in Strasbourg. The task of the court is defined under Article 19, Treaty on European Union. And the task of the court is to ensure that in the interpretation and application of the treaties, the law is observed. Member States shall provide remedies sufficient to ensure effective legal protection in the fields covered by Union law, and bear in mind the interaction between European and national law, particularly when the ECJ gives a ruling on something. So how do you think the judges are appointed? Think about, for example, how the Commission is appointed, how a British judge is appointed. Is it a political appointment? Is it through merit? We'll be coming back to this issue of how judges are appointed later on in the lecture. Now, there are certain areas regarding the ECJ's activities that raise concern. For example, is the appointment process transparent and accountable? There are also an increasing number of cases, particularly as the workload of the ECJ has got larger through a growing number of countries joining the European Union. For example, when the ECJ was originally set up, there were only 6 members, whereas now there are 28, and obviously the number of cases has increased as time's gone on. The cost of legal fees is also prohibitively expensive in a lot of cases. But the big criticism of the ECJ is the length of time it takes to actually reach a judgment. A good and quick judgment can take up to 2 years. So it's not a quick process taking the matter to the ECJ. A single judgment is issued and there's confidentiality of deliberation, supported by all judges, and no dissenting opinions are published. This is obviously different to the situation that we have in the UK, where each judge gives his or her individual point of view on a particular case, and they may or may not all agree. So the system of reporting cases is different at European level than it is at national level. By the same token, it could be argued that the ECJ is actually quite secretive in terms of how it comes to its decisions. Equally, they like to present a uniform front, so it really depends on how your interpretation of this political will. So who can bring actions before the court? So as a general principle, the court is asked to examine compliance with EU law. And you can get different combinations of people referring cases. So the most common one is the Commission versus a member state. The Commission is the guardian of the treaties, and one of its tasks is to ensure that EU law is being applied correctly. In the event it's not being applied correctly, the Commission can issue a reasoned opinion in which they bring the infringement to the attention of the member state concerned, and if that isn't informally resolved, normally within about 2 months, then the Commission has the option to refer the case to the ECJ. Now, because of this, the Commission obviously has very extensive powers to ensure that EU law is being correctly applied, but it's also politically sensitive, and the Commission does have discretion as to what cases it brings before the ECJ. If you have a look at the number of infringements by different member states, and these are reported, not every single infringement of EU law is referred to the ECJ. In fact, 98% of all cases are actually dealt with at the informal stage when the Commission sends a reasoned opinion. Another option is for a member state to bring a case against another member state. This is very, very rare because obviously it's politically sensitive. Because it's such a thankless task and politically damaging and bad for inter-community relations, most member states will tend to leave disputes like that up to the Commission as a kind of neutral third party. Another option is for member states to bring a case or a claim against either the Commission or the Council. Another common one is the Commission cases between the Commission and the Council, and also the European Parliament and the Council, or the European Parliament and the Commission. Now, it could be argued that actions before the court and judgments is just another kind of politics. So the cases are about real problems, but they're also about the power struggle and the balance of power between the EU and its member states, and between the institutions. A major beneficiary of ECJ judgments has actually been the European Parliament. In the early days, when the European Parliament was trying to find its voice and moving away from being known as a talking shop to becoming a genuine political body in its own right, the European Parliament was very active about challenging the status quo that existed at that time, particularly in disputes between the European Parliament and the Council. And that, as with each treaty amendment, the European Parliament's powers have got stronger, and that's partly been because of the outcome of various ECJ cases in favour of the European Parliament. And ever since the Treaty of Lisbon was passed, the European Parliament now shares legislative power with the Council, so it is a fully fledged legislative body. Compliance with the court's judgments. States may delay compliance, but the court has power to impose fines. But, that said, no member state has ever defied the rulings of the court to the end. Compliance is based on the political and legal commitment of the member states to the EU, and it's evidence of the court's authority and also of the binding nature of EU law. Contrast with this with, say, compliance rates of judgments given by the ICJ or even the European Court of Human Rights. They are more, judgments by those courts are more likely to sometimes be, if not ignored, then there might well be some attempt to stall the process or look at ways of avoiding implementing the court judgment. But in the case of the European Court of Justice, because of its clear status as the top court in Europe, there is a limit to how far the individual member states will actually challenge decisions of the ECJ. Plus, as the court has a very wide-ranging power to impose fines, there comes a certain point when the whole process just ceases to be financially viable for member states. Plus, there's also a general attitude of compliance anyway. Now, one of the interesting points is the relationship between the Court of Justice and the national courts. National courts have the power to apply EU law themselves, and that isn't limited to the top courts, that's any court. They may choose to ask the opinion of the court, a process known as a preliminary ruling. Fundamentally, if a court is dealing with a case before it which actually involves EU law and is unsure what legal principles should apply, then it can apply to the ECJ for a preliminary ruling. The way that works is the national court explains the problem that they're dealing with, and they put various questions to the ECJ and say, please can you give a ruling on these points, because these are the points that we're unsure about. And the ECJ will then come out and give their preliminary ruling, which can then be followed by the national court. If they do apply for a preliminary ruling, then the court concerned has to comply with the ruling of the court. You can't go through that whole process and then say, thank you very much for all that effort, but we're going to ignore it. So, preliminary ruling procedures are a very effective way for the courts to ensure that EU law is being applied uniformly and the similar principles being applied in different countries. It's also a very effective procedure in the sense of preliminary ruling procedures invoked frequently, and it's something that the courts encourage, nor do they limit applications purely from the top courts. Any court in the EU may apply to the ECJ for a request for a preliminary ruling. Now, another point to look at is the impact of the court's judgments in strengthening European integration. The EU legal orders distinct from the national and international orders. Right? In terms of basic principles, EU law is binding on member states, and the principle of supremacy effectively says that EU law has supremacy over national law in the case of a conflict between the two. So if you take a national law, which is, say, supposed to implement a directive, and then it turns out that this national law is not actually being implemented correctly, and there's a conflict between the parent directive and the enacting national law, then in that situation, EU law has supremacy over national law, and the judge interpreting the case will fall back on the parent directive using the principle of indirect effect.
In terms of key judgments, the court has strengthened the internal market rules of free trade. Cassis de Dijon is the classic case for that, it's also been very active about ensuring and upholding EU rights for individuals vis-à-vis their states, and has revolutionised conventional rules of international law, and EU law is actually stronger than international law, and has far higher rates of enforcement. The impact of the court's judgments, in short, is that it expanded EU law beyond the letter of the treaty and was guided by the spirit of the treaty, which is known as a teleological interpretation. So, do European citizens benefit from EU law? Individuals can claim EU law rights in national courts, such as equal pay, non-discrimination, and consumer rights. Freedom of movement is another common one, which again the courts have very actively upheld. And to what extent does the doctrine of supremacy, i.e. EU law having supremacy over national law, benefit European citizens? This is quite a contentious topic. It's a very well-established principle from a point of view of EU law, but in terms of mainstream awareness, this is perceived as A, being quite contentious, but also quite challenging, and it's something that in the UK that there is a particular problem with, partly for constitutional reasons. One of the fundamental principles of the UK Constitution is the idea of parliamentary supremacy. Parliament can legislate on what it likes, and nobody can tell the UK Parliament what to do and what to legislate on, which was fine until we joined the European Union and had to follow this doctrine of supremacy. And because of this constitutional conflict, it's one of the areas which the UK has had some difficulty over, despite the fact that actually a lot of the key cases were actually rulings given by UK judges who upheld these principles. The Court of Justice in EU law has actually been very active in cementing European integration, and the ECJ has worked actively to ensure economic, political and legal integration. Law is a strong force bringing the different member states together, and the legitimacy of the EU law rests arguably on the political will of the member state and the rule of law, the binding strength of the EU law, and this can be contrasted with UN and other international organisations that don't benefit from such a strong rule of law system. Now, one of the common criticisms of the court is that it's a political rather than a judicial institution, because it's, certainly through the early years of European integration, it's very active in political sense. There's certainly been political activism favouring the promotion of European integration at the detriment of national sovereignty, and people who are critical of this principle are often also critical of the role of the ECJ. The ECJ has gone beyond the letter of the treaty, and some argue has acted beyond its judicial role. In some cases, it's almost assumed a lawmaking role by creating judge-made law. This is one of the ongoing debates that you get in any legal system. According to the basic principles of the separation of powers, states are divided up into three organs, if you like. You have the legislative, the executive, and the judiciary. the executive think of law and policy, the legislative pass law, and the judges interpret law. But in any system, there are certain circumstances where judges will make law. For example, in the UK, the case of Donahue versus Stevenson established the whole law of negligence. Parliament hasn't passed laws on negligence, it still remains a common law area. And in that situation, the national judges created a new area of law which was then exported around big chunks of the world. So any legal system will often have this as an issue of the role and function of judges. Do they interpret law? Do they make law? And that's certainly been a point for criticism that's been levied against the ECJ. Some argue that the ECJ is a driving force of federalism, turning the treaty between states into a kind of de facto constitution of the EU, known as constitutionalisation of the treaty. So, whilst the ECJ is recognised as being the top court in Europe, it's also recognised that the people who work there are true experts in European law. There are also criticisms of the role and function and practices of the ECJ, and depending on your view on Europe, you may or may not agree with the stance taken by the ECJ in certain cases. In defence of the court, member states, through the treaty, gave the court the power of ensuring that the law was observed. So the ECJ is not a creature of its own rights. It came into existence because the member states created it. It has also worked tirelessly to strengthen inter-community free trade, which is a priority objective of all the member states. So from that point of view, the ECJ and the member states are in the same song sheet. Also, the ECJ can only rule on the cases brought before it by EU institutions, member states, and by reference to national courts. The ECJ can't create a case or a theoretical case and create its own principles. It can only give a judgment on cases that have been brought before it. The major judgment from the late 1960s to 1980s was a period of political slowdown. Court stepped in where the politicians dared to tread and achieved judicially too risky for the member states to achieve politically. Theorising judicial activism, this can be construed as either intergovernmentalism or neo-functionalism. Conclusion. So, in the case of European integration, has this occurred by treaty or can judge make law? Well, at one level, one could argue that the member states determine the terms of the treaty, and the member states have the power to amend the treaty and restrict the power of the courts. But today, none of them have actually done so more than seriously. This is a driver of European integration beyond the limits of political action by the member states. And the EU institutions and the member states abide by the court ruling, thereby giving the EU and the ECJ legitimacy. Right, in this seminar, we'll be looking at classic cases of capital division, mutual reference to the national standard, and there are textbooks of the key capital cases. Finish on. There's a link here to a local woman, a landlady, and she wanted to subscribe to a Greek sports channel so she could show sports events to her pub. And you follow the link, then you'll be able to read. Thank you.